And please let the participants come in because it will take time for them to settle down. Friends, I was waiting for your connections to stabilize. Welcome to this CHETNA series of lectures organized by UGC. We bring experts in this CHETNA series of lectures to speak about the best practices in higher education. Today, I see overwhelming response from across the country, and I even see some classrooms where students are sitting and watching this program. Many, many thanks to all of you for your enthusiasm and interest in joining in today's CHETNA series of lectures. This lecture, as is the practice with the CHETNA series of lectures, is also live streamed on all the social media platforms of UGC. So typically, thousands of people watch these lectures. Friends, in today's CHETNA series of lectures, we will be speaking on the new criminal laws in India and some key insights of these criminal laws. As you know, in 2023, the Indian Parliament passed 3 new criminal laws. And these laws are a mark of an end to the colonial era laws that we had in our country. The primary objective of these new criminal laws is to provide enhanced protection for the poor, marginalized, and vulnerable sections of our society, while also coming down heavily on organized crime, terrorism, and many such other offenses. These new laws is the passing of the new laws by the Indian Parliament is considered to be one of the biggest revamping of the Indian criminal justice system. As young people, as students in our higher educational system, and as faculty members and staff members, often we come across issues related to, for example, sexual harassment or cyber crime and other criminal acts. It is therefore necessary for all of us to have a clear understanding of these new criminal laws so that whenever such incidents happen, as a responsible citizen, we should be in a position to tackle such things in our society using the new criminal laws. And that's the reason why we want to bring more awareness among our students, faculty, and staff in the higher educational institutions about the new criminal laws passed by our Indian Parliament. We also, in addition to this lecture, we have also requested some time ago all the higher educational institutions to conduct workshops, seminars by inviting faculty members from the law universities or senior students from the law universities can be invited to give lectures and interact with our young students in the university system to provide them guidance and support on issues related to these new laws so that reporting of crimes and also navigating through the legal system becomes easier for all of us. And there can be no better person to speak about these new criminal laws than our today's speaker, Professor G.S. Bajpai. He is the Vice Chancellor of the National Law University in New Delhi. And in today's lecture, he will emphasize on the importance of knowing about these criminal laws and why these criminal laws were passed by the Indian Parliament. Professor G.S. Bajpai, we extend a warm welcome to you on behalf of all those who have joined us on our social media platforms and on behalf of UGC. Sir, please go ahead.
Namaskar. Good afternoon to all. My sincere gratitude to the chairman, Professor Jagdish Kumarji, for having me today here to speak upon a very important subject, that is new criminal laws, key insight in India. I also welcome all the participants who have joined from all over the country in a big number, and I'm sure that this interaction would be very, very useful. Friends, before I start, let me say in the outset itself that this is a very vast subject and also a very complex subject. I'm given to this understanding that the people from all kinds of backgrounds are joining this interaction, and not only law person. So I'll deliberately keep the language of my talk a little simpler so that the benefit of this discussion could reach to all the people who have joined here. Secondly, I'm also told that some use of Hindi here and there will also be there, so that those who are conversant with Hindi and other language, they will also be benefiting from this. So before I start my presentation, I would simply say that the people have various notions about criminal laws. But let me tell you, criminal law in any country is one of the most crucial facets of governance. It is no longer merely a punitive system, but a major means of dispensing justice, ensuring peace and order in society. Because sometimes we feel that the role of criminal law is to punish people. But criminal law can be very vital in the progress of the nation in terms of contributing to the social and economic development of the nation. So as a public utility, criminal law catered to the evolving needs of society, responding to new challenges through continuous change and reform. Effective criminal law significantly impacts national development and social change. So I am not keeping the focus very narrow. Rather, the people from all social science background would understand that how criminal law is a lifeline of the society, because in a peaceful order, the prosperity emerge. The national development cannot happen if you have a orderly society. So Indian criminal laws have experienced episodic changes over near 7 decades in its major criminal statutes. So it's not that this is happening first time, but the difference is those changes were piecemeal and very, very episodic. Something happened and we have launched some kind of reform here and there. However, for the first time, we are witnessing a very comprehensive revamping of these laws through an engaging process of consultation and communication. Before delving deeper into this discussion, it is essential to understand the necessity for such extensive reforms in Indian criminal law in India. That question is very, very important. So for the sake of understanding, I'll just share a small PowerPoint to navigate you through some pointers and some discussion around that subject. So here we go, and this is the PowerPoint that I'm sharing with you, and it will straightway take you to the question that I have raised, that in today's agenda, I will be dealing with these 7 issues which would cover the requirement of this conversation. First of all, need for criminal law reforms. Why suddenly we have undertaken such a massive revamping of criminal laws which were there in existence for more than 7 decades and 50 years old, and IPC, Macaulay created, and all those criminal laws. And how this process has happened, because many of us may not be knowing, many of you may not be knowing what was the process. And then we will look at these laws at a glance, and we'll look at the key reforms which have happened. So first thing is, what is the need? And when I take you to the need, I'll simply say that these laws were rooted in the extensive codification that was conducted in early 19th century, that is 1830, by the first law commission when it was appointed under the chairmanship of Macaulay. Before that, the laws were not codified in India. So Indian Criminal Code came into Indian Penal Code came into being. Although piecemeal changes were made to these laws over a century and a half, but the fundamentals remained the same. That is the whole colonial, backdrop in which we have been functioning so far, as far as the criminal laws were concerned. And despite these 76 years of independence, the laws reflected the socio-political belief and legal discourses of the colonial era. तो हम इसको ऐसे समझ सकते हैं कि जो पुराने कानून थे उसका एक संदर्भ था। वो संदर्भ ये था कि ब्रिटिशर्स उस समय चाहते थे कि जो भारतीय स्वतंत्रता संग्राम के जो कार्यवाही उस समय चल रही थी उसको किसी तरह से सप्रेस करने के लिए एक हार्श लॉ, लेकिन उस हार्श लॉ में कहीं ये बात नहीं थी कि न्याय प्रमुख बिंदु, उसमें पीनल कोड हमने बनाई थी, हमने जस्टिस कोड नहीं बनाई। अब हम उसको भारतीय न्याय संहिता कह रहे हैं। न्याय शब्द नहीं था, उसमें पीनल था, बिकॉज आइडिया वाज पिनिटिव। और ये 19th सेंचुरी की भी बात थी। दूसरी बात which is very important, this law reform process, how did it happen? I wish to share that in 1919 and 20, this process was initiated by the government of India, and they wanted the comprehensive reforms. And I am telling you, I am congratulating, and rather I am acknowledging this publicly, that never before in the history of this country, no government has approached for the law reform process in this democratic way, whereby a lot of stakeholders were invited to make suggestions. So the government requested law universities and various police academies and all kinds of groups to give some input so that a framework of change for these laws could be evolved. It is in that context, a committee on reforms of criminal law was constituted. And I am very happy to share that I have served as a convener of this committee on criminal law reform. And we have gone through the process of a competition where we have made presentation, and our presentation was accepted, and this committee was constituted by the government of India, consisting of members and a very huge research team consisting of 60, 70 people. And on 4th May, this committee was functioning, constituted under the chairmanship of the Vice Chancellor of the National Law University, Delhi. And that was the COVID period. And you can imagine that the task of consultation, going out, and all those things were very difficult. But it was a daunting task which was undertaken by a very dedicated group of people, guided by the government. And we have embarked upon a very exciting journey of undertaking those spectacular reforms that you are witnessing now in the forms of these 3 very distinctive laws. So the committee had a mandate to suggest a criminal law reform which should be principled, because this principled word was never there. And I will also take you to a very small context. When earlier criminal laws were made in 1833, Constitution was not in existence. So therefore, no constitutionality question was involved. Now we have a constitution, we have an independent judiciary. Therefore, laws ought to be principled, effective, and efficient. So these 3 keywords were guiding the whole journey to ensure that the individual and community get benefited from the process of law reform. And constitutional values are to be kept on top, and values of justice, dignity, and inherent worth of the individual. So this was the little context about the process. So I have said about the need for criminal law reform and the process. Unfortunately, we don't have much time, because the task that has gone in 2 years cannot be really summarized in few minutes. So this committee has submitted its report to the Home Ministry of Home Affairs in March 2022. As many as 158 deliberations were took place at our level with the stakeholders, and even several times more than these deliberations, which took place at the level of the government in terms of consulting the key stakeholders for drafting these bills, and this process continues. So criminal law reform process was actually undergoing for good 4 or 5 years, and then the Bharatiya Nyaya Sanhita bill, the Bharatiya Nagrik Suraksha Sanhita bill, and Bharatiya Sakshya Adhiniyam were introduced in the parliament on 11th of August 2023. They were referred to this Standing Committee on Home Affairs. So after the introduction of these bills, this committee had also occasion to have large number of interactions and consultations with various stakeholders. Again, the suggestions were incorporated, and I'm very happy that we were fortunate to be part of this process. And then again, these bills were reintroduced, on 21st December, and the assent of the Honorable President was received on 25th of December. And as we understand now, the acts are to come into force from 1st July 2024. So this was the journey. This was the journey, which is very, very important. But I think in the background, there are certain things which I would like to share. Probably there is no other occasion to, tell you these things. Many people would say, why reform, and what was the direction of this reform? So before the reform process could begin, there was a consensus which was drawn as to what should be the principles on which this law reform should be based. And you can see these 11 principles. All the law students who are attending this gathering, they must understand that law reform doesn't take place in a vacuum. It's always very contextual and need-based and goes in certain direction. And these 11 principles are emanating from the constitutionality, the emphasis of judiciary in terms of a number of Supreme Court decisions, so primacy of constitution, primacy of human rights, relationship of the individual with the state, victim justice, victim rights vis-a-vis accused, fair investigation, fair trial, transparency, technocentricity, principled sentencing. So these were the guiding force behind this whole process. And now you will see, when you read these laws, I think you can easily decode the changes that have been made. You could link some of those changes fulfilling the requirement of these principles. तो आप ये देखेंगे कि अगर एक प्रिंसिपल यहाँ पे बताया है कि इंडिविजुअल वर्थ इज वेरी इंपॉर्टेंट, तो इंडिविजुअल राइट्स को एक बहुत ऊंची प्राथमिकता पे रखा है। और इसी तरह अगर आप देखें कानून में अगर कोई संशोधन किया गया है तो इस लिहाज से किया गया कि जो व्यक्ति है, जो स्टेट के सामने खड़ा हुआ है पूरी प्रोसेस को फेस करने के लिए, कहीं उसके राइट्स पे कोई समस्या प्रस्तुत ना हो, और अकाउंटेबिलिटी सिस्टम किस तरह से बनाया जाए इस पे भी बात की गई, और विक्टिम के राइट्स किस तरह हो इस पे बहुत बात की गई। मैं आगे इस पे आपसे चर्चा करूंगा। Now we will go one by one to get those key insights for which we are gathered today. To start with Bharatiya Nyaya Sanhita. At a glance, if I make a small, glimpse to you, so we know that this Bharatiya Nyaya Sanhita now has as many as 358 sections. Earlier, it used to have 11 sections. Now, in this Sanhita, there are 20 new offenses introduced. There are 19 provisions which have been deleted after long deliberations. And there are 33 instances where the punishment has been increased, because we wanted a system which should definitely invoke some kind of effect in the society for compliance. Fine. These British era laws were having the quantum of fine very, very less. Now this has been enhanced in 23 offenses. And thereafter, new punishment scheme has been introduced, chapter have been reorganized, and rechapterization has been done. So in next 2-3 slides, you'll see how this has happened. And in case of, so I'll come back to this slide again, but before moving ahead, I'll also take you to Bharatiya Nagrik Suraksha Samhita, in which the update or the change has happened on major 8 fronts. What are those 8 fronts? First is the technological updation and advancements. Second, significant changes have been introduced in the law of arrest, law of bail, reorganization of prosecution system and reform, sentencing reform, victim justice provisions, introduction of provisions relating to speedy justice, and impetus to forensic science. So these were the main, changes along which we will discuss the issues. Now I'll come back to Bharatiya Nyaya Samhita to just take you little deeper into it in very simple language. So these were the 6 very important areas which you can easily see in terms of the changes which are now happening. So first of all, you see there was a lot of discussion around the provision of sedition under the erstwhile 124A IPC. Now, I remember my discussions in the committee. I was of the opinion that since there is no longer any kingdom or any emperor, so the term Rajdroh or sedition is no longer relevant. Because even if somebody does some harm to the state or to the government or to any system, he is not essentially targeting the emperor or Raja. He is actually indulging into a subversive activity against the state. Therefore, you will find under section 152, any act that endangers the sovereignty of the state in terms of affecting the unity and integrity of India. So now India has been placed here rather than any state or any emperor. And this introduction of 152 is actually, it replaces 124, and now the punishment is up to 7 years. Now, you must have heard a lot about mob lynching, the instances of mob lynching. In our IPC, the term mob lynching is not defined nor it is covered. Now, this BNS under section 103 subclass 2 clearly covers the instances of mob lynching where any person who indulged into the commission of any kind of act which actually affects the provide any kind of danger or commit murder on the grounds of race, caste, community. This would be punished with the punishment of, I think PPT is not, now it must be, it is now punishable with death or imprisonment for life. And similarly, section 117 also linked with it, where grievous hurt, if it is caused in this process, is also liable for punishment under this section. Now, a very interesting addition, if you see, has taken place as far as the So new provisions of petty or organized crime. This is very important. Not new provision for organized crime. So any person causing death will be punished with, death or imprisonment for life, liable for fine for 10 lakhs. In any other case, he will be punished with imprisonment for 5 years and may extend to life. Now, idea of introducing organized crime and petty organized crime under section 112 is a great, initiative. because these crimes are also becoming very common. Especially, this is very insightful to understand the introduction of petty organized crime. What are those petty organized crime? We see these crimes happening very often in the community, but they were not covered. They were being covered under normal provisions of IPC. But now, for instance, any act of, theft, snatching, cheating, unauthorized selling of tickets, unauthorized betting, gambling, selling of public, examination question paper, or any other similar criminal acts which is committed in an organized manner would be covered now under IPC. It was not there. So I think it provides a great avenue to deal with these crimes strictly. Similarly, you see the provisions relating to terrorism. Now, terrorism was being dealt under UAPA Act separately. Now, idea of bringing this particular offense in the major criminal law, that is BNS, is again a very important exercise. I think those who come from the law background and sitting here, they would understand that BNS is a substantive law. And the role of the substantive law is to define crime. Therefore, this defining function of crime rests with the substantive law. And you will notice that here the terrorism has been added, and any act which threaten or likely to threaten the unity, integrity, sovereignty, and security or economic security of the nation would be dealt under this section. So this is very, very important. As snatching, chain snatching, 304 of BNS. So chain snatching instances were also increasing. Initially, they were being dealt again under the general sections of hurt under IPC, or robbery under IPC. Now, snatching is a separate offense, punishable with imprisonment of maybe extend up to 3 years, and also with fine. So these are very interesting. Now, another very important uh, inclusion, it is sexual intercourse by employing deceitful means. Now, this is a very unique inclusion. Earlier, this particular crime was limited to the offense of rape, where consent was sought through deceitful means, and it was restricted to only those instances. So, like for instance, you have the media, what media calls love jihad cases, where essentially the person from two different community to be there to cause the act of love jihad, where some deceitful means are employed to lure a person or to entice a person. Now, all those things have been given away, and in any circumstances, any deceitful method is employed, section 69 would be attracted, where this offense is punishable with imprisonment up to 10 years. So under any circumstances, if any kind of deceit is produced to cause this, and this sexual intercourse would be liable for punishment under this section. अब मैं आपको थोड़ा सा इस पे ले चलता हूं, जहां हम मॉडिफिकेशन देखें कि मॉडिफिकेशन क्या किए गए, क्योंकि बहुत से ऑफेंसेस सारे बदलाव नहीं किया गया। बहुत से लोग सोचते एकदम नया लॉ हो गया, कुछ नए प्रावधान जोड़े गए हैं, कुछ जो जो एग्जिस्टिंग प्रावधान थे उनमें कुछ चेंज किया गया है। तो यहाँ कुछ चेंजेस किए गए हैं, वो बड़े इंटरेस्टिंग। जैसे मैंने आपसे अभी कहा था कि इसमें करीब करीब 358 सेक्शंस हैं जो 20 चैप्टर में है, और पिछली जो हमारा आईपीसी थी उसमें करीब करीब 23 चैप्टर में हमारे 511 है। इसका मतलब है आईपीसी को बहुत कंसाइज किया गया, और कंसाइज करने का अर्थ ये है कि इसमें हमने एक स्पेस देने की कोशिश की है कि किस तरह से क्लैरिटी से इसको दें। इसमें चैप्टराइजेशन बड़ा इंटरेस्टिंग है, मैंने दूसरे पॉइंट पे लिखा है चैप्टराइजेशन। चैप्टराइजेशन आप देखें तो थोड़ा चेंज हुआ है। जैसे मैं आपको उदाहरण के तौर पे ये बताना चाहूंगा, जो ऑफेंसेस अगेंस्ट वीमेन एंड चिल्ड्रन, उसको एक सेपरेट चैप्टर में हमने रखा है, चैप्टर नंबर 5। व्हाट डज इट मीन? It shows the priority of the government or priority of the state to emphasize the crimes which are committed against women and children. You would be surprised to know that in the IPC, there was no chapter on crime against women and children. Rather, these offenses were clubbed under a single chapter called Offenses Against Human Body. Now, by this rechapterization, a new emphasis and a new intent has been provided in terms of prioritizing these offenses to deal with this in a very stern manner. So therefore, this new chapter is there, which is chapter 5 of Bharatiya Nyaya Sanhita. Now, there are other regroupings. I am not going criminal breach of trust. They have been clubbed together. I am inclined to attract your attention on this gender neutrality. What is this gender neutrality? Because in the earlier version of IPC, a number of offenses were only limited to be committed by a man against the women. Now, those offenses have been made gender neutral, especially the offense like using criminal force to with the intent to disrobe a woman, or voyeurism, or procurement of any person. So all these offenses have been made gender neutral, and you will see that this change has been effected to make the laws more and more, gender neutral. Another you must have seen in the newspaper, there was a lot of hue and cry on hit and run case related matters. Now, where a driver escapes without reporting the same to the police, though this provision is yet to be notified, but I think this is also going to be, because we have given a graded liability principle, that if a driver, instead of running away, comes voluntarily and report the offense to the police, would attract lesser degree of punishment than one who escapes. Now, deletion. There are certain deletions of the offenses which are also very, very important, because I have just mentioned that the offense of sedition under section 124A has been now deleted, and I need not to give you the background, but there were certain accusations that this provision was being misused number of times, and there was little vagueness in this provision, and already the Supreme Court had given a very clear version on this. Therefore, this has been deleted in the BNS now. Section 377, dealing with the unnatural offenses. Already we know in Navtesh Singh Jauhar case, the Supreme Court has given the verdict, and now this stands deleted. Attempt to commit suicide has also been deleted. Now, I'll come to a very interesting part of this discussion, because IPC, I said, or the substantive law, is meant to define the crime and also to prescribe the degree of punishment. The scheme of punishment in our laws is such that they are on a scale. So there is a minimum sentence, there is a maximum sentence. Here, the point number 1 will attract your attention, because I'm saying there is an introduction of mandatory minimum punishment in 23 offenses. These offenses are basically organized crime, terrorist act, theft, dacoity, and many other. Now, you will ask a question that why mandatory when the punishment is on a scale? So this is the discretion of the judge as to how much punishment is to be given to the offender. But idea of providing mandatory minimum punishment in certain offenses is to convey the intolerance to those offenses on the part of the state. Means we are very clear that if somebody is found to be indulging in XYZ act, he would minimum attract this much punishment. So this is called the minimum mandatory. This is again a very different kind of thinking to make law a little stricter in certain cases. Now, enhancement of punishment has also taken place, because we know that the punishment for good years has never been, increased, and we were continuing with the same quantum of punishment. Now, increasing the punishment is not a routine function. I always say neither the introduction of crime is a routine function, nor prescribing a punishment is a routine function. This is not the occasion, but the criminal law scholars would understand that the principles of criminalization are actually in the backdrop of all this discussion through which we decide. But here, enhancement of punishment has happened. Now, enhancement of fine has also been brought in as many as 83 offenses, such as voluntary act of endangering life, personal safety, assault, and other kind of offenses. And last is most important. The student of law must understand the introduction of community sentence. Now, those who are the student of criminology and criminal law will understand that in many countries, instead of sending the people to the jail for petty offenses, the idea of community sentence has been introduced. We have as many as 5 crore cases pending in our courts. The occupancy of prisons goes up to 68 to 70% in certain cases. There is no room in prisons to accommodate prisoners. The under trial prisoners are, as I have said, 65 to 70% in most of the jails. Now, in such a situation, the justice would be denied if a person is kept on waiting for the trial to happen. And therefore, new forms of punishment have to be imagined. And BNS introduces very subtly this community sentence. And I'm sure that the combination of community sentence and summary trial, which is provided in, I'll come to summary trial in CRPC, or procedural law. I think this combination can prove to be very vital in next 5 to 10 years for this country. If invoked effectively, this provision would be in a position to actually mitigate a large number of cases which are choking the process of criminal justice. So in any situation, 30% cases can be dealt. This is my rough estimation through community service, where the person, instead of being sent to the prison, would be asked to serve an institution. If it is a doctor or a professor or an engineer, they will be asked to do a community service free of cost in the interest of the society, rather than making them unproductive and languishing them in the prison. So there is a huge scope of discussion on this. Now I'm coming to the second law, which is Bharatiya Nagarik Suraksha Sanhita. This is the most important law, and this is the destiny of people and the country is decided by this law. This is the procedural law. Now, you must have read that a lot of discussion in the media has happened. But I think, friends, we are living in 21st century era, which is marked by the emerging technology onslaught. We are living in an era where AI is now about to come and dominate a number of engagements, or human engagements, professional engagements. Now, law and criminal justice system has always been very, very conservative as far as technology is concerned. It has never responded very efficiently and effectively to the technological developments which were happening. Capturing the technology for making the justice efficient is something which is very, very important. I am happy to share that a comprehensive move we find in these laws, where we have introduced audio, video, electronic means. And we have not only introduced, we have defined that what would be the electronic communication, because this terminology was absent in the previous version of our laws. Now, courts have been made empowered to issue summons using electronic communication. I'll mention to you in Delhi alone, more than 30,000 proclaimed offenders are roaming because they remain unable to be contacted by the system because their addresses are found to be incorrect, their details are not there, and there is no other method of communicating with them because we have never given emphasis. And in the entire country, hundred thousands of proclaimed offenders are roaming. They have been declared proclaimed, but they are not contactable. They are never turning to the trial. And therefore, this electronic communication will make the things very, very efficient. And you see that this technological update is something which is for the transparency and fairness also. So suppose police is conducting a raid or police is searching a premise, it has to be recorded so that the person is not put to any kind of inconvenience. Now, if you see the electronic communication, uh, especially the information relating to the commission of a cognizable offense, it can be in electronic form also. So report FIR is now possible to be lodged in an electronic method. Final report, closure report, physical presence of the accused at the time of framing of charge has been dispensed with where the accused is present through audio video electronic means. In a country like India, a person living in remote village coming to the district headquarters, traveling overnight, or losing their job and employment in work days, a person can simply attend it through the mobile phone. This has been enabled. Evidence of a witness. The witness are the friends of the court. They are put to a number of inconveniences because they are supposed to be before the court. Now they can use the audio video electronic means to deposit to depose before court and give the testimony. Judgment to be uploaded on the court's online portal within 7 days. This is very, very important. Now, the victim is not knowing what happened in the case. He is post to pillar, roaming around. Now, within 7 days, this will happen. The last section, this 530 is very, very comprehensive, where this law finally says that all trials and all proceedings under the code may be held in electronic mode by use of electronic communication or use of audio. So all the proceedings can now happen. Last week, I was attending a conference in Thailand, and I came to know that China has gone completely to online litigation in civil cases, completely. So they are dealing with 40% of their civil cases through online litigation. And what they are calling AI justice as a program is being nurtured so effectively. India has to actually go into the direction of technology and using it for the efficiency of the criminal justice system. Now, prosecution system has been in great neglect throughout. In this law, we find the directorate is supposed to be set up. Eligibility of director and deputy director has been laid down. And all those things are now at place, whereby the prosecution system, because prosecution represents the victim, but prosecutors remain somehow neglected, or they remain quite aloof from the whole process. Now there is a lot of thought which has been invested in this law under various sections which are on your screen. Now I'll also touch the most key area in which I am personally very invested, and I have worked in this area for several years, and I have tried to do my bit to introduce some of the changes which are victim-centric changes, because these criminal laws were created for the accused. The criminal laws in this country were never created for the victim of crime. They have been created for the accused. So all the rights and privileges were concentrating or confined to the accused person. And therefore, you will find the accused to have a lot of benefits and privileges. So he has the benefit of doubt, he has the benefit of probation, he has the benefit of bail. But person who has been harmed is found, he will find himself little away from the system. Therefore, he is a forgotten fact in the criminal process. Now you'll see the victim right to participation and protection has been preserved through various sections under the भारतीय नागरिक सुरक्षा संहिता. और इसमें आप पाएंगे कि ये एक बहुत प्रोग्रेसिव थिंकिंग है क्रिमिनल लॉ और क्रिमिनल जस्टिस में कि विक्टिम को किस तरह से सेंट्रल स्टेज दी जाए. और अभी इसमें मैं ये भी कह रहा हूं कि इसमें और बहुत स्कोप है, लेकिन ये एक बहुत अच्छी शुरुआत है. सो इफ यू सी अंडर 173(2), a copy of FIR to be provided to the victim in addition to the informant. You will be surprised that the term victim could be introduced in our laws only in the year 2008, and after that we have forgotten. But here in all the sections we said the copy of FIR is the right of the accused, right? But it is equally a right to be given to the victim of crime. Now this law clearly obligates the enforcement authority to provide a copy of FIR, because victim at times does not know as to what are the contents of the FIR to be able to really take the case forward. Police officer is required to inform the victim and informant about the progress of investigation within 90 days. You'd be surprised again that in the previous version of criminal procedure, the police was under no obligation to provide any information to the victims of crime regarding the progress of the case. On human ground, they may provide, but on legal ground, they were not supposed to. Here, they have been legally obligated to serve the victim in terms of providing this information. Now, supply of copy of documents like police reports, FIR, statement of witnesses, all these to be given. So this is the emerging era of victim justice, because we call criminal justice. Victim justice has been recognized and realized. Now, in-camera trial has been institutionalized. In many cases, sexual offense cases like in POCSO, in all other cases, the victim can do the trial process by being in camera. Now, mandatory first aid, because soon after the victimization, medical assistance is the first requirement. Again, the agencies are not under obligation. Here, the obligation of medical treatment in such cases has been, put on the authorities. The state government must prepare and notify a witness protection scheme. Now, this is, I don't have time to elaborate upon this, but as I have said, the victim is also a witness of crime. There is no protection, there is no assistance to the victims and witnesses in our country, because we have not done much in this area, unfortunately, unlike all other countries. But I think there is a subtle and very modest beginning where we are saying the state government will now notify a victim protection scheme where they will spell out the rights of the witnesses, the kind of protection they can have, and what are the other arrangements from the state that they can receive. And the second most important thing is speedy justice, because we all know that the justice in our country goes very slow and a lot of cases are pending. Now, what has been done? This is a very bold step. To give you a background, in past 50, 60 years, time and again, successive bodies, commission and all that, they have been talking about, can they put certain timelines for police, prosecution and judiciary to expedite the matters. But only this time the state could actually display this boldness in terms of making certain timelines. So victim and informants are informed about the investigation within 90 days. This is the very important development. Initiation of trial in absentia against proclaimed offenders within 90 days. So if in 90 days the proclaimed offender doesn't, proclaim मतलब जो निकल गया चला गया वो लौट के नहीं आ रहा है इन्वेस्टिगेशन के समय से या ट्रायल के समय से, उसके खिलाफ 90 दिन के भीतर एक ट्रायल शुरू हो सकता है. Summary trial mandatory for petty and less serious offenses. This is very important. So I think many more offenses have been included in the summary trial. Are those trials which are very quick, they do not follow very lengthy process. So what does it mean? If you are adding more and more cases under the bracket of summary trial, it means you are expediting the justice to be able to dispose more and more cases. Timelines बड़ी interesting है, आप इनको देखें at point number 4. FIR to be taken on record 3 days from the informant signature. तो अगर एक informant FIR करके गया है तो आपको 3 दिन के अंदर उसको FIR में कन्वर्ट करना पड़ेगा. अभी क्या हो रहा है पूरे देश में, बहुत जगह ये हो रहा था कि person goes to the police station, he or she is registered, that we will see, let us see whether this offense is good enough to be recorded as under FIR or not. No, they will say, we will make a preliminary inquiry before we make a FIR. What is that preliminary inquiry? वो ललिता कुमारी ने कहा. अब उन्होंने कहा, even if you have to make a preliminary inquiry, वो 14 दिन में खत्म होनी चाहिए. Otherwise, preliminary inquiry was going on for 6 months, 8 months. Putting strict timelines would demand a greater degree of accountability on the part of law enforcement agencies. That is the whole, remarkable thing here. Supply of police report documents. So वो कभी देते ही नहीं. आप कभी भी, even if you are lawfully in full right to have these reports, you would be, asked to wait for some period for this reason or the other. Here, 14 days. Further investigation after filing of charge sheet to be completed. Now, this is another very problematic part. वैसे बोल दो. So now I'll come to mostly these timelines and speedy. So let us see. Judgment 30 days, framing of charges 90 days. So these are very interesting timelines. Last trial in absentia, I have already mentioned that the person, if he doesn't appear before the court and he evades the trial, the proceeding ex parte can be initiated. Now, forensics has been added. Forensic science, the introduction of forensic science upon receipt of commission of an offense, the officer in charge police station shall cause a forensic expert to visit. So now there is a greater degree of deployment of forensics. So this is very important. Now, last leg of my very small 2 slides, because Bharatiya Sakshya Adhiniyam are very important, is a very important law, but not many changes have been introduced here. But I am just mentioning key changes in a very quick way in the next 2 slides. So first of all, electronic or digital records are given the same legal effect. This is very important because earlier there was no scope for electronic or digital record to be considered as, as evidence. Now they have been given the status of primary evidence. Earlier, even the secondary status was disputed in those cases. Now, we have also defined all these things, that the definition of a document now includes electronic and digital records, which may be emails, logs, documents, or anything. Now, reformulated evidence definitions have also been caused, where we includes the electronic statements and records, aligning the contemporary technological use in documentation. Electronic record admissibility is now there, which are printed, stored, recorded, copied, or kept in any electronic form. They are all become the part and parcel of evidence and to be produced in the court, and they would be admissible. Conditions have also been spelled out when these are preserved. Now, second is scope of evidence has been enlarged. This is my last slide. Expanded secondary evidence. The scope of this evidence is expanded to include oral and written admissions. So this is very interesting. So in case of large quantities of records being not examined, an expert opinion will be considered as secondary evidence. Now, expert opinion in its earlier version were only limited to certain, confined to certain special fields. Now, additional areas have also been included. So means people from all other fields, maybe engineering, technology, and all other fields can come as an expert witness to the court. And production of documents, especially government documents which are classified or restricted, they are protected from being presented in any trial. Confession. Confessional statement induced by threat or not to be, admitted. And again, these things are very, very important. So I would only say in the end that new criminal laws focus on justice rather than punishment. Because ultimately, in this era, we need to talk about the justice, not only justice, the quality of the justice, and how all the stakeholders are placed in the process of criminal justice in a rightful manner, because justice is no longer a charity. Earlier, justice used to be a charity given by the emperors. It has become now right. And even from the right, we have moved to participation. And these laws are very insightful because they are enabling the participation of these stakeholders in a big way. And I'm sure that countries' development and destiny would be significantly shaped and impacted by the introduction of these laws. Challenges remain in terms of training and all those things. But let me tell you in the end that maturation of a criminal law is a long time process. IPC or CRPC could become IPC and CRPC after a long, long journey. So I think we should allow some time to these laws to mature. And we should also exercise some patience in terms of cooperating the organs of the government to see that the implementation of these laws become, fruitful for the progress of this nation. Thank you so much for your patient hearing.
Right. Thank you, Professor Bajpai, for a wonderful, comprehensive lecture on the new criminal laws introduced by the Parliament. It is not easy to do justice to this topic within 1 hour, but you have done a wonderful job. In a very simple language, you have brought a lot of clarity in our minds about this new criminal laws. Thank you very much. We will take a couple of questions because of lack of time. I will read out a couple of questions that I have received from the audience. One question is, you spoke about the community sentence. So if such a thing is given to a person, how do you implement and monitor this community sentence? So this is the question.
Yeah, thank you so much. This is very important and this is very new for us. But I'm sure that the only substantive part of this provision has been spelled out, where we have crafted the provision. Implementation mechanism can be, to my mind, there are various options. So we have District Legal Service Authority. We have legal aid groups, voluntary. So I think implementation part has to be now spelled out. Now court will give an elaborate order that this person would be placed, say, in a community center to be monitored by the local district authority, or this job can be given to the district collector or DM or the legal officer who is employed. And I think certain templates have to be created to do a periodic monitoring to be submitted to the government, and possibly this is possible. And I'm very sure the Ministry of Law and Justice and the state governments would be able to do this.
Right. Another question is, today, protecting our environment is also one of the important responsibilities for all of us. Is there anything in the new criminal laws, if somebody does which destroys the environment, is there some discussion about this?
Yes. So this part is already covered to a certain extent, where if you harm the biodiversity or the environmental resources, so they are already covered. But I would also like to say that we have an Environmental Protection Act, which is a separate law. So in our country, we consider these to be civil issues, not criminal issues. So I would suggest that let us not bring them core criminal issues. Let them remain civil issues where we can charge the fine and damages for the wrongdoer and fine them rather than sending them to jail.
You're right, right. What about cruelty to animals? Is it covered?
Yeah, so cruelty to animal is covered already to very restricted degree. But again, we have a law, protecting the animals from any kind of cruelty. So there is a special, that is called the special law. So animal cruelty is very well protected under that law. Let me give that this BNS is a general major criminal law. So local and special criminal laws are taking care of various local and special issues such as juvenile, women, animal cruelty, environment. So I think a specific law are the what we call minor laws in legal language. They will take care of that.
Right, right. So one last question. In view of these new criminal laws, what kind of training should the law faculty have to effectively teach these new laws to the students?
This is a very good question. I would suggest, I have said in the beginning, that your teaching must emphasize the principles of criminal law more rather than instrumental aspects of criminal law. You try to convey what are the principles on which this criminal law reform has taken place, or for that matter, what are the core criminal core principles which are in the in the backdrop of these reform. So I have spelled out 11 principles of criminal law. I think if you start discussion in your class, because the laws have been captured from those principles, there are broader principles on which we have a consensus. So we have a consensus that human rights should be protected. We have a consensus that primacy of the constitution need to be protected. Now all law will flow from those broader principles. So principles are very important. So I would suggest that the criminal law teachers must start doing a very intensive, substantive, and critical criminal law training. Critical means critique. Why we are having these laws? Because you have to critique the earlier version of the law.
Right. Just one more question has come. While many of these laws may be relevant to India, are there some points in these new criminal laws which could be applicable in other places outside India also, for them perhaps to refine their own laws?
Yeah, so every law is territorial, specific, because this law is basically for India. We can try people or deal with the people who have committed crime here. But I think that we have certain extraterritorial jurisdiction in certain cases where we have treaties with other countries where we can, make the arrest, get the people arrested and import them and try them here like any ordinary offender. So that type of arrangement was already there before. So probably that will still functional. There is no new change which has been, affected as far as these laws are concerned at this stage.
Right. Very nice, Professor Bajpai.
Thank you,
It was
sir.
a wonderful lecture, and
Thank
it
you
is
so much, sir.
widely watched across the country. Even in the classrooms, the students are sitting and watching your lecture. And this video will be available in all our social media platforms. Please do inform your friends. Please do tweet this talk in your social media handles so that more and more people can watch and benefit from this lecture. So with those comments, Professor Bajpai, with your permission, we would like to conclude now.
Thank you so much. Thank you, everybody, for joining. My pleasure.
Namaste.
Namaste.